As this YSL RICO case carries on, the lawyers are getting into it over discovery issues. Let's talk about it. My name is Jamahl Kersey. I'm the principal attorney at Kersey Law, a boutique criminal defense firm in San Diego, California. And in this video, we're talking about discovery issues between the lawyers in this YSL RICO case. So after a person is formally arraigned and enters their not guilty plea, the prosecutors sometime thereafter will turn over the discovery. It can be as short as, the same day or within a few days, or it can be sometimes weeks before the prosecutors have the discovery together to turn over to the defense. What the discovery is basically your police reports, photos, videos, witness statements, medical records, if that's applicable, basically whatever evidence the DA believes points to a person's guilt. But also the DA has to turn over exculpatory evidence as well. So if there's any evidence that points to a defendant's innocence, then they have to turn that over as well. And so generally speaking, the discovery in your run-of-the-mill case is only going to be around 30 to 50 pages. In some instances, it could be a couple hundred. But in a case like this, in a big RICO case with multiple defendants, so we have almost 30 people named in this indictment, there's going to be a lot of discovery, and especially in a case that's been building for many years. So in this case, there are likely thousands of pages of discovery, thousands of photos, and hours of recorded videos that are amongst the discovery in this case. In the smaller cases, the DA will usually give you like your discovery in an envelope. So there'll be a manila envelope that has those, 30 to 100 pages of discovery. But in the bigger cases, your discovery will likely be provided on a USB, like a thumb drive, or even in your larger federal cases, you might get a whole hard drive. So a whole hard drive of information. Or nowadays in this modern digital age that we're in, you can get discovery via Dropbox links. And it sounds like that's how the discovery is being shared in this case. So there was a hearing last week in front of the judge where the defense was complaining that they hadn't received all of the discovery and that they were having problems opening the Dropbox links. These sort of technical issues can happen, but it can be really frustrating when, as a defense attorney, you're asking the DA and their paralegals or whomever for the discovery and they're dragging their feet, they're not putting out the discovery, or, when these technical issues arise, they're not sorting them out in a timely fashion because you got to get going on your defense. Your client naturally is wanting to see the discovery, wanting to get started on forming their defense strategy. And if you don't even have the discovery, then that's impossible to do. The reality is judges do not like getting involved in these type of discovery disputes. They really, they'll oftentimes say, hey, you guys are professionals. I'll let you, handle this like adults, because it can get really petty. I've seen situations in motion hearings where lawyers are bickering at each other like children, and judges, like, the last thing they want to do is get involved in a battle regarding, discovery issues. So if the parties can't work it out on their own, then they can file what's called a motion to compel discovery. And in that case, the judge can act as a referee and make sure that the parties are complying with their discovery requirements. Specifically, in this case, the lawyers are wanting the recording of a witness interview from 2019. And so neither the name of the witness nor the substance of the actual interview was discussed. As you know, there are YSL members who have now agreed to cooperate with authorities, but also just in terms of witness protection, they don't want to go on the record, because the transcripts and the public forum is open to the public. They don't want names getting out, prematurely or unnecessarily. And so they didn't mention who the person was or the substances of the conversation. The other issue that they're concerned about is apparently prosecutors allege that there was a nurse who attempted to smuggle unspecified contraband into Fulton County Jail. However, at this point, none of the evidence regarding that alleged attempted smuggling has been turned over to the defense. And so obviously the defense has a right to that information. And so the lawyers need an opportunity to be able to review this discovery internally, right? So they go over it, make their notes, point out the red flags and everything. Then they need an opportunity to review it with their client. So they go over the evidence with their client and get their take on it, that, hey, this is a lie, this is an exaggeration, this didn't happen like this actually went down in this way. And so they need to be able to form their defense strategy and possibly, have their investigators go out and interview witnesses, basically to build their case. If they don't have the discovery, then they can't do this. And so that's where this discovery dispute arose in front of the judge. At this point, the trial trial is set for January of 2023, which, we're in August, so that is right around the corner. And so with these new allegations that were recently filed a couple weeks ago and these discovery issues, I mean, who knows if this case is actually going to be ready for trial in January. It's more likely that this is going to get pushed back. And so we might not see a trial in this case until perhaps next summer or even late fall. Well, that's all for now. If you got something out of this, please make sure to show me some love and hit the like button. Make sure you subscribe to the channel and turn on those notifications so you never miss a new video when it drops. As always, I want to thank you so much for watching, and until next time, peace.